Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. It is not enough that the defendant merely associated with the person committing the crime or unknowingly or unintentionally did things that were helpful to that person or was present at the scene of the crime. The evidence must show beyond a reasonable doubt that the defendant acted with the knowledge and intention of helping that person commit possession of firearms and dangerous weapons in federal facilities. A defendant acts with the intent to facilitate the crime when the defendant actively participates in a criminal venture with advanced knowledge of the crime. The government is not required to choose between proving whether the defendant personally committed the crime or whether the defendant aided and abetted another in committing the crime. The government, however, is required to prove beyond a reasonable doubt either that the defendant personally committed the crime or that the defendant aided and abetted another in doing so, as defined in these instructions. As noted, defendant Kenneth Madenbach is charged in count 4 with theft of government property in violation of 18 United States Code 641. In order for defendant Kenneth Madenbach to be found guilty of count 4, the government must prove each of the following elements beyond a reasonable doubt. First, the defendant knowingly stole and converted to defendant's use a 2012 Ford F-350 truck with the intention of depriving the owner of the use or benefit of the Ford F-350 truck. Second, the Ford F-350 truck belonged to the United States. And third, the value of the truck was more than $1,000. The term knowingly in this context means the same as for count 1. As noted, defendant Ryan Bundy is charged in count 5 with theft of government property in violation of 18 United States Code 641. In order for defendant Ryan Bundy to be found guilty of count 5, the government must prove each of the following elements beyond a reasonable doubt. First, the defendant knowingly stole and converted to his own use or the use of another cameras and related equipment with the intention of depriving the owner of the use of this property. Second, the cameras and related equipment belong to the United States. And third, the value of the cameras and related equipment was more than $1,000. The term knowingly in this context means the same as for count 1. A defendant may be found guilty of theft of government property, count 5, even if the defendant personally did not commit the act or acts constituting the crime but aided and abetted in its commission. To prove a defendant guilty of possession of theft of government property by aiding and abetting, the government must prove each of the following beyond a reasonable doubt. First, theft of government property as defined in these instructions was committed by someone. Second, the defendant aided, counseled, commanded, induced, or procured that person with respect to at least one element of theft of government property. Third, the defendant acted with the intent to facilitate theft of government property as defined in these instructions. And fourth, the defendant acted before the crime was completed. It is not enough that the defendant merely associated with the person committing the crime or unknowingly or unintentionally did things that were helpful to that person or was present at the scene of the crime. The evidence must show beyond a reasonable doubt that the defendant acted with the knowledge and intention of helping that person commit theft of government property. A defendant acts with the intent to facilitate the crime when the defendant actively participates in a criminal venture with advanced knowledge of the crime. The government is not required to choose between proving whether the defendant personally committed the crime or whether the defendant aided and abetted another in committing the crime. The government, however, is required to prove beyond a reasonable doubt either that the defendant personally committed the crime or that the defendant aided and abetted another in doing so, as defined in these instructions. And that is the end of that particular jury charge. Next, let's see what we have for some literary practice. This is called Beware These Car Loan Pitfalls. Ready? Here we go. Which is better, getting a car loan from the dealer or from a bank? 8 of 10 car loans are arranged by car dealers, and for good reason. Convenience for one, you can stroll into a dealership in the morning, take a test drive, arrange for a loan, and park your new car in the driveway by afternoon. Dealers also work with lenders who finance buyers with poor credit ratings, and dealers may offer a cut rate or even 0% loans. But such benefits often come at a price. A dealer's F&I, finance and insurance office, is a motherlode of profit. Dealers typically arrange loans with banks or other lenders, and the California Car Buyers Bill of Rights allows them to tack on up to 2.5% for themselves. Arranging your own financing from your bank, credit union, a peer-to-peer lender, lending club, Prosper, etc., or Rich Uncle may give you a lower interest rate. Still, it's best to work all options. Here are some tips for dealing with a dealer. Clean up your act. Go to annualcreditreport.com to get free copies of your credit reports. File disputes with the reporting agencies if you notice errors. If your reports show you pay your bills on time and you don't have too much debt, your score should be good. A dealer or lender will run your score and must provide it to you. Score above 700 and you'll qualify for good interest rates. Score below 600 and rates will be ugly. Comparison shop. Obtain a quote from a bank or another lender who doesn't have a vested interest in whether or not you buy a particular car. Knowing the amount and interest rate you qualify for gives you a benchmark to compare with a dealer's offer. Ask the dealer's F&I guy or gal to beat the bank's rate. Avoid talking monthly payment. Negotiate only the price of the new car, the price of your trade-in, and the loan interest rate. The F&I person can cut the monthly payment by increasing the length of the loan, but that also increases your overall interest costs and the likelihood that you'll owe more on the car than it's worth the next time you car shop. If you can't afford the payment on a loan of less than 4 or 5 years, buy a less expensive car. Beware the yo-yo. This means thinking you've closed a deal at one interest rate only to have the dealer later tell you that you must pay a higher one. If a California dealer's contract states that a sale is conditional upon financing approval, the dealer has up to 10 days to place your loan with a lender. During that time, the dealer can require you to return the car or sign a less favorable contract. But remember, if you don't agree to new terms, the dealer must return to you any down payment or the car you traded in. Beware the pack. Costly add-ons, extended warranties, credit, life insurance, etc. must be clearly disclosed in the contract, and the dealer can't require you to buy them as a condition of the loan. Study the contract as if your financial life depends upon it, because it might. Make sure all dates and information are correct before you sign. Dealers have been known to inflate down payment amounts and buyers' incomes to put buyers into loans they can't afford. One more thing, the Federal Consumer Financial Protection Bureau regulates car loan lending activity by banks and other financial services, but Congress exempted car dealers from such oversight. Another reason for caution. So, which is better, dealer arranged financing or self-arranged financing? You be the judge. Let's get back to this short jury charge, or jury, and these jury instructions are for punitive damages. Punitive damages. Ready? Here we go. In determining the amount of punitive damages to award Ms. Bovang, you must keep in mind that punitive damages are not intended to and may not be used to compensate Ms. Bovang for injuries, but rather to punish a defendant and to deter similar conduct in the future. Accordingly, in fixing a sum to be awarded, you should consider the degree to which a defendant should be punished for his or its wrongful conduct, and the degree to which an award of one sum or another will deter that defendant or persons or entities like him or it from committing wrongful acts in the future. In arriving at your decision as to amount of punitive damages, you should consider a defendant's net worth and the impact of paying that award. An award should be limited to the amount reasonably necessary to achieve the goals of punishment and deference, and should not be so high as to result in the financial ruin of a defendant. Moreover, any award of punitive damages must bear a reasonable and proportional relationship to Ms. Bovang's actual injury and the compensatory damages that you awarded her. In calculating a punitive damages award, you should consider 1. The nature and reprehensibility of the defendant's conduct, including the character of the wrongdoing and the defendant's awareness of what harm the conduct caused or was likely to cause. 2. The amount of time the defendant engaged in reprehensible conduct, and 3. The defendant's financial condition and the impact your punitive damages award will have on the defendant. Where punitive damages are claimed, all the circumstances connected with the conduct at issue tending to exhibit or explain the motive of the defendant may be considered by you. The plaintiff, on her part, may show that there was express malice, and, on the other hand, the defendant is entitled to the benefit of any circumstances tending to show that he or it acted under an honest belief that the conduct complained of was justified. See what else we have here for some literary practice. This is called This Land is Your Land. A handy guide to your national treasures. Here we go. Steam floats over the flat, dry land, escaping into the surrounding thick green forest. Everything is calm. Then, seemingly out of nowhere, a plume of water and steam shoots into the air, higher and higher, until it reaches 140 feet and then crashes back to earth again. The stillness returns. The eruption of the Old Faithful Geyser in Yellowstone National Park is drama at its best, and once you've seen it, it's impossible to forget it. It's also easy to see why in 1872 Congress made the effort to protect the area from settlements by designating the region America's first national park. That effort grew into a larger movement to preserve these kinds of sites where the natural beauty inspires and educates visitors, and eventually led to the creation of the National Park Service, NPS, established by an act signed by Woodrow Wilson on August 25, 1916. Even now, when most of us think of the Park Service, we picture that geyser along with other awe-inspiring sights such as the Great Smoky Mountains, scenic byways, the Grand Canyon's iconic vistas, and Yosemite's towering waterfalls. But over the years, the NPS has grown into much more than a steward of parklands. Today, it also administers national monuments, recreation areas, seashores, lake shores, and historic parks and memorials, to name just a few. It runs programs focusing on wildlife conservation, natural resources, and outdoor recreation. It includes 408 sites that cover more than 84 million acres. There's an NPS site in every state: the District of Columbia, Guam, American Samoa, Puerto Rico, and the Virgin Islands. So as the Park Service heads into its centennial celebration, we decided to take a look at all it's become over the past 100 years. 130 National Historic Parks and Sites, 2,500 National Historic Landmarks, 90,000 venues on the National Register of Historic Places. see what other literary material we have here. Okay, this is a short literary. It's called Heart of All the Golden West. San Francisco's Soma district forms the city's new focus. Ready? Here we go. My wife and I both fell in love with San Francisco early and hard. I fell almost literally when I was 10, visiting from Southern California with my parents. I climbed onto a cable car, nearly slid off, then steadied myself for the clanging, precipitous ride up Nob Hill. I was hooked. My wife Nancy was 12 when she visited from Stockton with her BFF Suzanne. She still recalls how they went to Fisherman's Wharf and ate at Alioto's. We felt so incredibly glamorous. Love of San Francisco is, in fact, one of the passions that has united us over 20 plus years of marriage. But great cities, like great marriages, grow and change. Nowhere is that more apparent than in San Francisco and its south of Market neighborhood. Long a faded industrial district, Soma, which stretches south from Market Street for 20 blocks, is the heart of 21st century San Francisco. Mission Street vibrates with Manhattan-like energy as pirouetting cranes signal the rise of another tech boom funded office tower. Last May's reopening of the doubled in size San Francisco Museum of Modern Art pinned it to the world map of must-see art destinations. So Nancy and I set ourselves a challenge on all Soma weekend. Would we love the new SF as much as we did? We did. Get back to some jury charge. This is actually a new jury charge, and it's called Notice of Final Charge to the Jury, Phase 1 and Special Verdict Form. Ready? Here we go. Members of the jury, it is now my duty to instruct you on the law that applies to the issue of fair use. A copy of these instructions will be available in the jury room for you to consult as necessary. It is your duty to determine the facts from all the evidence in the case. To those facts you will apply the law as I give it to you. You must follow the law as I give it to you, whether you agree with it or not. You must not be influenced by any personal likes or dislikes, opinions, prejudices, or sympathy. That means that you must decide the case solely on the evidence before you. You will recall that you took an oath promising to do so at the beginning of the case. In following my instructions, you must follow all of them and not single out some and ignore others. They are all equally important. You must not read into these instructions or into anything the court may have said or done as suggesting what verdict you should return. That is a matter entirely up to you. The evidence from which you are to decide what the facts are consists of 1. The sworn testimony of witnesses on both direct and cross-examination, regardless of who called the witness. 2. The exhibits which have been received into evidence. 3. The sworn testimony of witnesses in depositions and other proceedings read into evidence. 4. Any facts to which the lawyers have stipulated. You must treat any stipulated fact as having been conclusively proved. 5. Answers to interrogatories and requests for admission read to you during trial. And 6. Any facts that I have instructed you must be treated as having been established. Evidence may be direct or circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what that witness personally saw or heard or did. Circumstantial evidence is proof of one or more facts from which you could find another fact. By way of example, if you wake up in the morning and see that the sidewalk is wet, you may find from that fact that it rained during the night. However, other evidence, such as a turned-on garden hose, may explain the presence of water on the sidewalk. Therefore, before you decide that a fact has been proved by circumstantial evidence, you must consider all the evidence in the light of reason, experience, and common sense. You should consider both kinds of evidence. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. It is for you to decide how much weight to give to any evidence. You should base your decision on all of the evidence, regardless of which party presented it. All right, we will stop there. That will conclude our literary and jury charge practice.